Hello, it's Phillip Taylor from Richmond Green Chambers. I'm also the editor of the Barrister Desk at the Mallet Street Gazette. And this is a case clip about a famous decision which has now come into our system called Hall versus Simmons in the year 2000. I've got the actual title up there. This is the law report. Very heavy, very busy and complex law report. It's got a number of other firms of solicitors mentioned in it, but it's a decision of the House of Lords, and it's an important decision because it exemplifies the way precedent works, because Rondell versus Worsley, which I reviewed in another case clip, was not followed, so the law's been changed, and it's been changed for policy reasons mainly, which is something you'll know about when you come to do your examinations. But let me just tell you briefly what the case was about and what the House of Lords said, because they weren't unanimous by any means, and obviously I, as a practicing barrister, have reservations particularly about this case. The position really is about immunity when it comes to the presentation of cases in court, and what the House of Lords had to do is it had to look at three separate cases where clients had brought claims for negligence against their former solicitors, and in each case these solicitors had relied on the immunity of advocates from suits of negligence, in other words being sued for negligence in the way that the case has gone, and the claims were initially struck out as unsustainable. The problem being, of course, the old floodgates argument. If you get one dissatisfied client wanting to sue, they're all going to do it, and that's really why the decision in the 60s on Rondell and Worsley had been followed by earlier decisions. However, this case then went to the Court of Appeal, who held that the claims fell outside the scope of this immunity, and therefore they should not have been struck out. So it then went up to the on appeal from the solicitors to the House of Lords, and their lordships considered whether the immunity should be abolished or whether it could still be justified on public policy grounds, particularly the public interest in preventing collateral attacks on court decisions and ensuring that advocates respected their overriding duty to the court. Now that's heavy language for the floodgates argument, and also the responsible behaviour of people like me when we're doing a case in court. Okay, so it went to the House of Lords, and what happened? Well, the House of Lords, their lordships, decided that advocates no longer enjoyed immunity from suit in respect of their conduct of civil and criminal proceedings. Now, in the criminal proceedings element, Lords Hope, Hutton and Hobhouse dissented. The view was that such an immunity was not needed to deal with collateral attacks on criminal and civil decisions. Rather, the public interest was satisfactorily protected by independent principles and powers of the court. Bit of the old inherent jurisdiction here. A collateral civil challenge to a subsisting criminal conviction would ordinarily be struck out as an abuse of process. In other words, if one did it, they would all be at it every time they were convicted, and then of course you'd get in a complete mess with the criminal justice process. So the public policy argument was against such a challenge, but their lordship said it would no longer bar an action in negligence by a client who had succeeded in having his conviction set aside. So you can see that there were various little riders to this. Similarly, the principle of res judicature, issue estoppel, and abuse of process, these are all mechanisms we use in court to try to sort out some of the ways in which a decision will go. All these three areas, as understood in private law, should be adequate, their lordships said, to cope with the risk of collateral challenges to civil decisions. In other words, far too many floodgate problems. Nor was the immunity needed to ensure that advocates would respect their duty to the court. I mentioned that a little earlier. That's basically us behaving properly. In that respect, their lordships said, a comparison with other professionals was important. So this is where the modern thinking comes in. Doctors, they said, are sometimes faced with a tension between their duties to their patients and their duties to an ethical code, but no one argued that they should have an immunity from suits in negligence. So we, of course, as barristers, advocates generally, were in a rather privileged position, which is now, of course, gone. Furthermore, the House of Lords said, experience in other jurisdictions, particularly in Canada, tended to demonstrate that it was unduly pessimistic to fear the possibility of actions in negligence would undermine the public interest in advocates respecting their duty to the court. Moreover, benefits would be gained from ending the immunity. Well, that's a matter of opinion in my submission, but there again, that's what they decided. It would therefore bring to an end an anomalous exception to the basic premise that there should be a remedy for a wrong, and there was no reason to fear a flood of negligence suits against barristers. Well, again, look at what's been going on. A huge increase, actually, in complaints. And I just wonder, I just put the question to you, whether in fact interests of justice has been served. I say that as a practitioner. The mere performance, their lordships said, by an advocate of his duty to the court to the detriment of his client could never be called negligent, and there would be no possibility of the court holding an advocate to be negligent if his conduct was bona fide dictated by his perception of his duty to the court. I think we all do that personally, and I'm a little surprised that they took that line. However, the courts would take into account the difficult situations faced daily by barristers working in demanding situations to tight timetables. Didn't mention the word finance, I noticed, but however, that's a good point. The courts could be trusted to differentiate between errors of judgment and true negligence, and in any event, claimants would face the very great obstacle of showing that a better standard of advocacy would have resulted in a more favourable outcome. Now, again, I doubt that, because they're very experienced guys on the bench, and they will listen to one side and the other, and then they will know the best course of action, generally speaking. Okay, there's the 1%, the very occasional case that gets into the papers which doesn't go the right way, but generally we have confidence in the bench. Now, unmeritorious claims against barristers would be struck out, they said, and the CPR had made it easier to dispose summarily of such claims. Well, I hope it does, and I hope we have trust in it. I notice Professor Zander doesn't, but that's another matter. Moreover, far from weakening the legal system, the abolition of the immunity, they said, would strengthen it by exposing isolated acts of incompetence at the bar. Well, again, I don't think there are very many of those, personally, and I think that's a bit insulting, but there again, that's a view from me as a practicing barrister. In contrast, the House of Lords said, confidence in the legal system would be eroded if advocates alone amongst professionals were immune from liability and negligence. It followed that it was no longer in the public interest to maintain the immunity in favour of advocates, and accordingly the appeals would be dismissed. So therefore, Rondell versus Worsley was not followed. Now, we've got, obviously, a lot of discussion has taken place about this particular case, or a series of cases. Let me just tell you the panel of people finding. You can read the case in detail. The panel in the House of Lords as an appellate jurisdiction were Lord Stein, Lord Brown-Wilkinson, Lord Hoffman, Lord Hope, Lord Hutton, Lord Hobhouse, and Lord Millett. And of course they're all well worth reading as judgments. But what I suggest you do is remember this case, because obviously it's now nearly 10 years since it came in. The bar has changed out of all recognition in those 10 years that I've been practicing, and of course I go back a long, much farther period of time within the profession. I don't buy some of the arguments, and I would suggest to you that one of the things you might think about in an exam paper, if this question crops up, is to balance the arguments about